I will call the committee to order. Before we get started with our official business today, wanted to recognize a couple of our committee members. Our committee member, Senator Pyle, had a birthday last week that I was neglectful and didn't give him a shout out, so happy belated birthday, Senator. And today is our Mr. Vice Chair, Senator Wilborn's birthday, so we'll be wishing Senator Wilborn a happy birthday today. Happy birthday to the both of you. So. And with that, then, we will get down to business. We will open the hearing on Senate Bill 105. If we could have the bill brief from Mr. Thompson, the reviser, that would be great. Thank you.
Thank you, Madam Chair. Good morning, committee. This is Jason Thompson with the Reviser's Office. Senate Bill 105 prohibits denial of a petition for expungement due to the petitioner's inability to pay outstanding costs, fees, fines, or restitution. This is a bill brought to you by the Judicial Council, and I see they've got a conferee lined up to speak to you soon about their process and their report. I'll briefly highlight that there are two sections in the bill, KSA 12-4516, which is in our Code of Procedure for Municipal Courts and deals with expungement of convictions and diversions for violations of city ordinances and the related arrest records. And then KSA 21-6614, which is in our Kansas Criminal Code, and that concerns expungement of convictions or diversions for criminal infractions, misdemeanors, or felonies, and the related arrest records for those. So the amendments to both of these statutes are substantively similar. There are some small language differences to account for municipal versus district court, but essentially they're the same in both sections. So in both places, we have a new subsection that provides determination of when the person satisfied the sentence imposed excludes the payment of costs, fees, fines, and restitution. And I note that because the current law requirement is preserved here so that a person is only allowed to petition for expungement after the person has satisfied the sentence imposed. And I saw the testimony that we were sent this morning gets into that a little bit more about why that can be a difficult barrier to overcome and how the clock starts ticking for when you can actually apply for expungement. So this would say that the non-payment is not part of that satisfying the sentence for this purpose. The bill also adds a new paragraph to a subsection in both sections of the bill that provides the court shall not deny the petition for expungement due to the petitioner's inability to pay outstanding costs, fees, fines, or restitution. It is specific that the petitioner's unwillingness rather than inability to pay those costs may be considered as a factor in denying the petition, but the court is not allowed to deny for the reason that they cannot, or for the inability to pay. Finally, the bill also adds a new paragraph to another subsection in each section of the bill to provide that the petitioner would still continue to be responsible to fully satisfy any of those outstanding costs. And for the purpose of collecting those costs, certain people would be granted access to the documents and information that have been expunged, but they're granted that access in order to collect those outstanding costs going forward. And I will stand for questions.
Thompson, committee, do we have any questions for the reviser? Seeing none, then we will invite our first proponent conferee to the podium, Mr. Ron Wirtz from the Kansas Judicial Council. And actually, I do have one question for the reviser. I'm sorry, Jason, did you indicate who brought the bill to committee?
Yes, Madam Chair, I mentioned very briefly that the Judicial Council brought this request to you.
Thank you. And thank you, Mr. Wirtz. If you'll introduce yourself and welcome to committee. Can you make sure your microphone is turned on? And there we go. And a tip, we've been asked for those participating on WebEx to hear us better if committee members and conferees all speak directly and pretty closely into the microphone. Thank you.
I'm an old criminal defense lawyer. I've been a public defender for something like 40 years before I retired 10 years ago. Been a member of the Judicial Council Criminal Law Advisory Committee for a long time too, and I was on this particular assignment. The Criminal Law Advisory Committee, their names are listed on the back of my testimony, is a broad-based group of people. It includes the director of the Kansas Bureau of Investigation, a retired police chief, criminal defense lawyers, assistant attorney generals, district judge, the whole gamut, private lawyers, public defenders, state and federal. So we've got a broad base of people that weigh in on these issues that are assigned to us. This particular issue, I think I saw the quickest agreement, consensus, if you will. Something needed to be done to allow something to be done, allow a person to obtain expungement if the only bar was their inability to pay fees, costs, restitution, or fines. Now, what's happening now, and this bill was brought to us by Kansas Legal Services, which does a lot of expungements and organizes expungement programs across the state, was there would happen to be what you might call a vicious circle. A person wasn't paying their court costs and fees. All they had was a job that allowed them to work hand to mouth. And there was some difficulty caused by the fact that they had the prior conviction. So they couldn't get expunged because they haven't paid their fees, and they couldn't pay their fees because they couldn't get it expunged, was essentially the circle we were in. And so the group got together and decided, first of all, we need to start the time running for expungement. A brief explanation: various crimes have lengths of wait after you've completed probation, sentence, etc. 1, 3, 5, or 10 years, depending on the crime. That time starts when sentence is completed. If you haven't, under current law, if you still have restitution or fines, your sentence isn't completed, so the time doesn't start running. This bill would say, let the time start when everything but the financial obligation has been completed. That way, for instance, somebody who has a battery conviction, a small bar fight or something, some small thing, they finish their probation. The person who has been able to pay off their probation, their time starts, say, if it ended August 15th, 3 years later, they would be eligible to expunge. The person who didn't have the funds or was unable to pay, if they couldn't pay, they can't start until it's actually paid. And therefore, it disqualified a number of people to the detriment of the collectors, the people that are trying to collect it. We were told from the testimony and information we received that everyone from the clerk of the district court to judges to people the judges or the clerk of the district court hires to collect the debts, the debt collectors, all are in favor of having this happen. The other thing this bill does, it prohibits the courts from denying expungement solely because of non-payment, inability to pay. If the person is being a deadbeat about it and refusing to pay, they could pay but they're not, the judge still has the discretion to deny expungement. And that was everybody agreed on that. The bill is owed. For your information, you probably know it, but the fines, costs, and restitution they don't ever go dormant, and they're not dischargeable under bankruptcy. So it's always out there. It can always be collected. And that's what the courts are doing these days. The third area that we approached was we worried that the people who were collecting the debt if it was expunged, would be denied access to the file in order to do the job they were hired to do. And so we added a section in there that specifically delineated those people who are entitled to access to a file that otherwise would be closed. And surprisingly, one of the people that did not get access to a closed file in many cases was the defendant himself or herself. And so that has been fixed with the amendment we've made here today. It's a relatively simple goal. I would be happy to stand for any questions at the end after you're through.
That'd be great. Thank you, Mr. Wirtz. And with that, then, committee, we will hold all the questions for our proponent conferees till we've heard from them. We will next invite Kendall Seal from the ACLU to the podium. Please introduce yourself and welcome to committee.
Thank you, Madam Chair and members of the committee. Kendall Seal, Director of Advocacy with the ACLU of Kansas. First, this bill is a positive step forward. We commend the committee for hearing it. It allows persons sentenced to be deemed completed and eligible for expungement regardless if the person still owes fines, fees, or restitution. It's commendable, and this is one major barrier that can be removed. We'd like to talk about or just raise some attention to the categorization of the unwillingness to pay. Because this bill leaves that potential open, it, on its face, appears to be an equitable solution, but in reality, the inability to pay determinations are frequently based on faulty criteria, outdated economic indicators, which are laden with implicit and sometimes overt bias. In many cases, the inability to pay or what the court may pivot to, which is an increased reliance on the unwillingness to pay determination, is really a reflection of potential bias by individual judges or the courts, rather than fair and objective standards. Simply put, these inability to pay determinations can lead to the continued systemic and structural racism in the criminal legal system and the reentry process. This loophole will disproportionately deny low-income Kansans the ability to reap benefits of their record being expunged. Finally, we recommend the removal of all docket and application fees associated with expungement, as these fees pose an inequitable barrier to relief. We urge this committee to pass SB 105 with the amendments and eliminate the unwillingness to pay language.
Thank you, Mr. Seal. Are there any other proponent conferees in the committee meeting room or on WebEx? Seeing and hearing none, committee, I will direct your attention to your committee folder and PDFs regarding proponent conferee written testimony from Michelle Ewert, Washburn Law Clinic, and John Jenks, Greater Kansas City Chamber of Commerce. With that, then, we will open it up for committee questions to our conferees. Senator Pyle.
Thank you, Madam Chair. I'm looking at the ACLU testimony, and it says ACLU of Kansas urges this committee to pass 105 if amended. Do you support the bill unamended or only with amendments?
We support the bill with the amendments.
So you do not support the bill as it is?
We support
I'm sorry, could you identify yourself again?
Thank you. Kendall Seal, Director of Advocacy, ACLU. We are neutral. I'm sorry, I'm on the wrong bill. We support in concept this bill, but we want the amendment in order to give our full support for it.
Thank you, Madam Chair. Thank you.
Mr. Seal, I have a couple of questions for you. Were any of the victim advocacy groups consulted by your group for their position on this bill?
That's a wonderful question. We have not.
If you could identify yourself
Kendall
again.
Seal, Director of Advocacy, ACLU. Apologies. We have not engaged victim advocacy groups with this specific language because, by my read of it, it retains the restitution fee. They will still owe the fees. It's just more so the barrier to accessing the expungement that we were focusing our attention
Thank you, and I don't mean just for your amendment, I mean in support of the bill in its entirety. Did your organization contact any of the victim advocacy groups to learn what their position was on it?
I'm not aware of that engagement.
Thank you. And I will ask Mr. Wirtz as well. Were any of the victim advocacy groups contacted or heard from in the drafting of the bill? If you could identify yourself too, please.
Onwards for the Judicial Council. Not directly. They were represented, if you will, by the prosecutors. There was talk about the notice that is given, and the prosecutors supported it, such as they could on behalf of the victims of this, with the concept that restitution would be more easily collected because the person would be able to get a better job and it would be more collectible. But to say we talked to them directly, no, we did not.
Thank you. Does the Kansas Judicial Council have a position on the amendment that the ACLU discussed in their testimony?
This is Ron Wirtz, Judicial Council. We discussed the issue of fees for the expungement of filing fee and decided not to make a recommendation on that. What we found through our inquiries and studies is that judges, upon filing of an affidavit of poverty, will often waive those fees. And frankly, if I can speak personally, the cases I've handled, in Shawnee County, it's fairly liberal. I can't speak for other districts, obviously, but the waiver of the fees is possible, it's allowed by law, and it's done.
So,
We didn't take a position on it.
and is that because currently in law, the judge would have the discretion to look at the poverty affidavit and determine whether the fees should be waived or not in that individual case?
Yes, in Shawnee County, what happens, they file, if they can't pay, they file a poverty affidavit. The judge has an actual in-person hearing where he questions the individual and makes sure that everything in the affidavit is accurate and that the person's on the up and up, and then he will grant it or deny it.
Right, that makes sense. Thank you, Mr. Wirtz. Committee, any other questions for our, yes, Senator Haley?
Thank you, Madam Chair. You actually brought up an interesting point. I would like to ask either Mr. Wirtz or Mr. Seal regarding the expungement proceedings. We had an expungement forum, whatever, in my county, Wyandotte County, where applicants were able to come. They had a small fee. And it was tremendous success. Worked in part with our district attorney, Mark Dupree. I don't recall at this stage that there was much involvement of victims' organizations in those applications. So I guess my question is, how often do victims' organizations participate in the questions for expungement? I mean, from my read, the time has been served already by the various applicants, and this is another phase well beyond the original crimes for which they were charged and convicted. Is that often that victims' organizations are involved in expungement at all when those requests come in, to your knowledge?
I helped run the
Mr. Wirtz,
Shawnee
if you
County version of the...
If you could identify yourself, please.
Ron Wirtz at Judicial Council. I can speak personally for it. The Judicial Council doesn't, but of the dozens of cases I saw, and having talked to lawyers at the legal clinic, et cetera, I don't know of any time that a victim has appeared and objected. The only barrier is that the prosecutor, when the petition for expungement is filed, is required by other statutory law to notify the victim that it's been filed, if they can find them. Many times in these expungement situations, though, so much time has passed that it is a fairly difficult task to actually find the victim. But they are required to make the effort, and that's why the case can't be decided generally the same day. There has to be a delay from the filing of it until the decision of the case.
Thank you, sir. Madam Chair, I think Mr. Seal, would you wish to weigh in? Is that what I was saying?
Is the same question directed to Mr. Seal, Senator?
It would be.
Thank you. Go ahead, Mr. Seal. Introduce yourself, please.
Certainly. Kendall Seal, Director of Advocacy, ACLU of Kansas. Just as a point of reference, that sometimes, I mean, my first 6 years was in litigation, and so my clients were often victims of domestic and sexual violence or trafficking, and some of those victims themselves were charged in other crimes and had fines and fees that represented barriers to their reentry into society. So some of what I'm suggesting is that some of the people actually impacted by the benefit of the expungement law, they themselves could be victims in other capacities or in other situations that they're trying to remedy the situation.
Thank you, sir. Thank you, Mr. Wertz. Thank you, Madam Chair.
Senator Corson.
Thank you, Madam Chair. Do you know, I mean, I'm envisioning that a lot of these cases where there is an expungement, there may not be a particular person who is a victim. And by that, I mean, somebody could be having expunged that they've had a minor theft, or somebody could be expunged that they, an underage person could have an expungement for possession of alcohol, or somebody could be arrested with a small amount of drugs, and that could be the nature of what is being expunged. And so it just seems like in some significant number of cases, there would not even be a victim to consult. Can you just talk about that issue and how predominant you think that is? I know you don't have an exact percentage, but that would strike me as often being the case.
Yes, Mr. Wertz.
Ron Wertz for the Judicial Council. You've hit the truth on the nose. Probably a large majority of the cases that come out for expungement are possession of drugs, property crimes of one sort or another. The property crimes, the criminal damage to property, some of them will have medical expenses, there's restitution, but a large number are crimes against the state, if you will. And so there's no victim to notify. The criminal damage to property cases, if somebody has comprehensive insurance, they really don't care. They've been paid, and they don't care. Or so much time's passed that nothing happens. But fines and restitution are the main issue in this. Judges will occasionally waive costs. I would estimate half or more don't have a victim other than the state of Kansas or the city making the charge. That's a wild guess, but that's a feeling I have. Does that answer your question?
It does. I don't know, Mr. Seal, if you wanted to chime in, but that does answer my question, and I very much appreciate it. And thank you, Madam Chair.
Senator Gossage.
Mr. Wertz. Thank you, and it's good to see you again.
It's good to see you again.
Served on the KBIDS board together.
Yes.
And my question is, how do you feel about this proposal from Mr. Seal and adding that, or that potential amendment to this bill?
The Judicial Council didn't take a position. If you're asking me personally, you could probably guess my answer. You kind of know me. I would support their position if it were me personally. The Judicial Council, however, takes no position on it.
Mm-hmm. So correct this, or help me understand as a non-attorney that's serving on this committee, and you've helped me on these things in the past, which I appreciate. So my understanding is that there are some folks that would be eligible for expungement. Am I saying that correctly? If but it's holding them back because the way it reads now is they would have to pay these fees first. And however, there are lots of folks that never have to pay fees because they were waived. Is that the inequity that we're looking at now?
When we were talking about waiving, first of all, we're talking about waiving fees. We were talking about waiving, you have to pay a fee to file the expungement.
Okay.
Okay, that's the first one we talked about. So that's a court fee, which the court has the power to waive. The other fees that are waived, the court costs, sometimes the judges will waive court costs. Sometimes someone will have an attorney fee, public defender, there's a reimbursement. They will sometimes waive that based on the person's ability to pay. But fines, like in DUI, there's a mandatory fine depending on the person's history. And there are fines allowed in virtually every criminal case. That if the judge imposes it, he could suspend it, or she could suspend it. But if it's imposed, it won't be waived and it will be owed. Restitution, the same way. If the judge makes a finding of restitution at the time of sentencing, which is required where restitution is needed, it is not waived and it becomes a judgment, just like I sued you and you owe me money at the time the judge imposes that sentence and imposes the restitution. And so that cannot be waived in any circumstance. So the two areas of fees, costs that we're dealing with mostly that cause the most serious problem and as a bar, and this addresses the most, is fines and restitution. And since they cannot be discharged either in bankruptcy or in collection procedures going dormant, et cetera, the district courts now hire collection agencies or firms to go out and collect the debts just like businesses do. And so this would allow that to continue to be done even if it were even if our bill is passed and the person has an expunged record.
Thank you so much for that thorough explanation. Thank you, Madam Chair.
Thank you. Mr. Wirtz, I have a follow-up question to something you had said that it's generally not the outstanding costs and fees that are the impediment here. It's the fines or restitution. And the outstanding costs and fees, those are those more related to the operation of the court and the court time involved in hearing the case and things like that, whereas the fines and restitution are directly related to the criminal conduct of the, in this case would be a petitioner petitioning for expungement. Is that right?
This is Ron Wirtz, Judicial Counsel. You've correctly stated it, yes.
And generally then, thank you, what kind of monetary amount are we talking about generally in costs and fees?
Just under $200.
Okay, so that's what we're looking at then. So
Not counting, if there's an attorney fee assessed, then that would be different. It would be on top of that.
are attorney's fees usually assessed in criminal cases?
If an attorney has a court-appointed lawyer, yes.
Right, for a public defender then.
Public
so.
defender or assigned counsel, yes.
Okay, but that answers my question then, thank you. Committee, are there other questions? Seeing none, then I will direct the committee's attention to our neutral conferee, Stephanie Bunton, CFO, Kansas Office of Judicial Administration. And it looks like Stephanie is on WebEx. So please introduce yourself and welcome to committee.
Thank you. Can you hear me okay?
Yes, we can. Thank you.
Okay, great. Thank you, Chair Warren and members of the committee for the opportunity to testify today. I am Stephanie Bunton, Chief Financial Officer with the Kansas Judicial Branch, and I am appearing today to offer neutral testimony. Senate Bill 105 would prevent a judge from denying an expungement petition solely because of a petitioner's inability to pay outstanding costs, fees, fines, or restitution. However, the bill allows for the collection of amounts due after an expungement has been granted. The current language in the bill may be problematic in a logistical or mechanical matter for the judicial branch based on our case management systems. The proposed amendment that we offer would permit a contracting agent operating under KSA 20-169 to have access to any documents and information regarding the outstanding cost, fees, fines, or restitution notwithstanding any expungement. Currently, the contracting agents who collect these debts for the state court system under KSA 20-169 enter an appearance in the case through the electronic filing system following debt referral. When that appearance is entered, the contractor can see the full case record. It is not practicable to limit the accessible information to documents that solely address outstanding debts owed in the case based on the capabilities of the case management systems currently in place. For this reason, we request an amendment to clarify that the entirety of the expunge case may be accessible for collections purposes. The contemplated language would strike the language that refers to any documents and information regarding the outstanding costs, fees, fines, or restitution, and replace it with language that permits access to the expunged record itself. A proposed balloon amendment is attached to my testimony. To address your earlier question, Chair Warren, we did just receive information regarding the number of expungements for district court cases each year. According to KBI, they processed 2,100 expungement orders from district courts in 2020. This represents $409,500 revenue to the judicial branch. That's $195 for each case with the docket fee and the surcharge. While there is still a mechanism for collecting these fees, they will not be collected up front, so collections will be slowed, and this will represent likely a decrease in our docket fees. So with that, I'm happy to answer any questions, and thank you for your time and consideration.
Thank you. Are there any other neutral conferees in the committee meeting room or on WebEx? Seeing and hearing none, we will open it up to committee questions for our neutral conferee. Do we have any committee questions? Yes, Senator Corson.
Thank you, Madam Chair. My question relates to this, but it's actually for the Judicial Council and for the ACLU. Do they have a position on this proposed amendment? Would they view this as a friendly amendment? Is this an amendment they'd be neutral on? I would just be curious if there was a position about that proposed amendment. Thank you.
Sure. Do either Mr. Wirtz or Mr. Seal want to respond? Mr. Wirtz, thank you.
Yeah, so my question is, the proposed amendment that Ms. Bunton just described, does the Judicial Council have a position on that amendment? And, you know, would they consider that a friendly amendment? Would they consider it they have no position on it?
I don't think we would have, I can't speak entirely for the full committee, but we discussed that there may be some glitches in terms of the administrative, and we tried to make it as broad as we could without going so broad that we disclose more than what the intention of keeping the spirit of an expungement in place. So a whole case file we didn't think needed to go to the collection lawyer. Simply the journal entry, perhaps, that would be enough. Now, if there's problems, we are not experts on the electronics, the system they've got. So ultimately, no, I don't think we have a position. Just any way that will work is fine.
Thank you, I appreciate it. Thank you. Thank you, Madam Chair.
Committee, any other questions? I do have one from Ms. Bunton. You mentioned $409,000 regarding, would that be court costs and fees that would be delayed in being collected, or could you clarify that? And please identify yourself again.
Sure. I'm Stephanie Bunton, Chief Financial Officer with the Kansas Judicial Branch. So for each expungement, $195 goes to the court in docket fee and surcharge. And so because right now, currently, the expungement fees are collected up front before the case is expunged, and this bill offers a mechanism that allows the fees to be collected later on the back end. And so since the fees will not be collected up front, there will be a delay likely in receiving the fees. And I can't say exactly when those would be received until we have an opportunity to operate under the provisions of this. But that will likely, we'll see a decrease in funding to the branch. So we may have to ask for supplemental funding. Because docket fees are used to pay our salaries and some of our operating expenses for the branch.
Right. Thank you for clarifying that, Senator Pyle.
Thank you, Madam Chair. Would you, based on what you've just said, collecting those at a later date, would you see any increase in administration costs or in any way see cost increasing due to the fact that you would be trying to collect those at a later date?
So they would be referred, if they are not paid in a timely manner, to our debt collection vendors, and there is a provision in statute for an administrative fee to be charged on top of debt collection. And then the debt collection fees are charged as well, but those are paid by the debtor.
So I believe, Madam Chair, the answer would be yes, there would be additional costs then.
We do not anticipate any additional costs. The issue would be the lag in revenue.
All right, thank you.
And potentially, though, a cost if they're never collected, because right now they have to be paid up front, and if the bill were to be enacted, it would be collected later, and that might then be a $409,000 difficulty. It's not really addressed in the fiscal note that we have from the division of the budget, but I'm hearing there might be some issues about that just from the testimony we're hearing today.
Correct. And I apologize. We just got those numbers. We requested them, and the email just came through right before my testimony from KBI. And so, yes, it could be a lag in revenue. It could also be a hole because the fees are never able to be collected.
Thank you. Mr. Wirtz, did you have a response to some of that?
Yes, Ron Wirtz, Judicial Council. I may be missing something here. The docket fees this bill directs are the ones that were not collected up front. They're the ones that have been owed and owed and owed and haven't been able to be collected. So I don't understand what the delay they're talking about is.
I think
I'm missing something.
I think the confusion is that the amendment proposed by Mr. Seal from the ACLU, that if these fees were to be waived, then it would be, not that they'd be collected later even, but it would be about a $409,000 budget impact, it sounds like.
Okay.
So
This bill as it stands doesn't address that, so I'm misunderstood, and I'm sorry.
Correct. No, I think the confusion was on this side of the podium, and appreciate you clarifying that, because right now the bill does not cause any delay or lag other than allowing the expungement to occur without the paying of the fees and the court costs prior to the petition for the expungement. Yes. Senator Pyle, did you have a follow-up question?
Yes, for Ms. Bunton. So if we get back to the collection of those fees at a later time, and I believe you said that the entity that would have to pay those collection fees Assume that you can't get the collection fees and attempts are made. Who absorbs that cost if they're not paid?
If you could identify yourself again, Ms. Bunton, thank you.
Sure. Stephanie Bunton, with the CFO with the Kansas Judicial Branch. And I had a little trouble hearing Senator Pyle, but I think he's asking if the collection fees, who absorbs those if they're not paid, if they're not collected?
Yes, that's
that
the
correct?
question.
Okay, so there are collection fees charged by the collection vendor, and those are just absorbed by the collection vendor if they are not collected. But as far as the actual fees, like the fee for the expungement and the surcharge, those would, I mean, they would just never be realized by the judicial branch. So we'd have to absorb them within our existing revenues.
That would be absorbed by the courts in their existing revenues. Is that the answer?
For the fees, there's collection fees charged on top, and those are absorbed by the collections vendor.
Right, right. Thank you. Committee, any other questions for our conferees? Seeing none, then, I'll ask then, do we have any opponent conferees in the committee meeting room or on WebEx? Seeing and hearing none, we do not have any written opponent testimony in your committee folders either. And with that, then, I will thank all of the conferees for their personal appearance and their appearance on WebEx and their very thoughtful and thorough testimony, and appreciate your time and effort on this. And we will close the hearing on Senate Bill 105. Committee, we will then turn our attention to House Bill 2026. House Bill 2026, you'll hear from the reviser, Mr. Thompson. It's the House version, if you will, of Senate Bill 3 that committee heard the end of January 26th. And this is the House version. And Mr. Reviser, if you could give us the bill brief on this, and if there were any differences in the House bill versus what we heard in the Senate, as well as the history of the bill. Thank you.
All right. Thank you, Madam Chair. Jason Thompson with the Reviser's Office. As you mentioned, House Bill 2026 does come to you from the introduced by the Joint Committee on Corrections and Juvenile Justice Oversight. They requested the same bill in both chambers. So you heard this as Senate Bill 3. The House did not make any amendments to the bill, and they passed it 123-0. Just looking that up real quick because you brought it up. So the bill that comes to you is the same bill you heard before. You may recall you were discussing an amendment when you worked the bill, but you paused at that point and put the bill aside for further action at a future date. So I won't go too far into the bill brief, but you'll hopefully recall that this is the bill that creates a certified drug abuse treatment program for people who enter into a diversion agreement. And it would be facilitated by allowing a county or district attorney to enter into a memorandum of understanding with either the chief judge of a judicial district to get court services supervision, or they'd enter into an MOU with community correctional services to get their supervision services. And there was some discussion of how the monies would be collected and where those fees would go, which was the subject of the amendment that you discussed, and I think will be the subject of some testimony later today. But at that point, I think I can stop and see if you have any questions.
Thank you, Mr. Thompson. Committee, do we have any questions for the reviser? Seeing none, then we will invite our proponent conferees, Scott Schultz from Kansas Sentencing Commission, and I believe he's appearing on WebEx. Mr. Schultz, please identify yourself and welcome back to committee.
Madam Chair and the members of the committee, Scott Schultz, Executive Director with the Sentencing Commission. Can you hear me okay, Madam Chair?
Yes, we can. Thank you.
You're welcome. Thank you for the opportunity to present testimony on behalf of the Sentencing Commission. This is a particular bill, obviously, as Jason indicated, Senate Bill 3. We also testified when that was before this particular committee. I'm not going to go into too much more detail. Our testimony is essentially the same. We are in support of it. The Kansas Criminal Justice Reform Commission, of which I'm a member, is also recommending passage of this to you. It obviously was successful not only last year when it passed 125-0 out of the House, but also this year as well. So I just wanted to go over just a couple concepts here. Diversion in the Senate Bill 123 program, just very quickly. Diversion, for those of you that are still getting up to speed as far as criminal justice matters, is a concept or procedure that is done between the offender and the prosecutor prior, some of the times prior, but sometimes the case gets filed and then diversion occurs later. But it's essentially a contractual agreement between the offender and the prosecutor to do certain things. And if they complete that in a certain period of time and don't commit new offenses, then that case is actually dismissed with prejudice. And so that's the part we're talking about here in terms of before the case even gets to any type of meritorious consideration by a court. This is the time between the prosecutor and the offender, and sometimes their attorney if they actually have an attorney. So this would actually, for those that are facing possession of controlled substances offenses, this would allow the prosecutors to receive state-paid substance abuse treatment for those offenders as a term and condition of that diversion. They don't have that right now, and then supervision would actually then be by agreement either with community corrections or court services probation folks, and that would be something that the agreements would be made with the prosecutors. Keep in mind that diversions are loosely regulated by statute, by Kansas statute. So that essentially means that prosecutors have the ability to craft them in any way, shape, or form that they want. So somebody in Sedgwick County may be eligible for a possession diversion where someone in Kingman County may not be. And so this bill does not make diversion mandatory in these situations at all. It is discretionary, and it's actually sought to incentivize prosecutors to be more willing to actually divert folks that that have addiction problems. One of the other things, it encourages offenders to complete substance abuse treatment, and in doing so, they avoid the stigma of a felony conviction, which essentially would be housing issues, of gaining good employment, as well as those housing issues. It also, importantly, from a treatment standpoint, there is a shorter time from arrest to treatment, and that is always a valuable thing so that person does not continue to use. Finally, two more things. It certainly allows the court then to spend more time on more serious offenders or more violent offenders. And thankfully, this particular proposal is supported by probation personnel. It does have a fiscal note to it, and I think that was something that I think perhaps in Senate Bill 3 that Senator Gossage maybe had a question, and that I had responded to that by email. I hope the committee actually received that on that particular bill, but there was a potential for a bad impact on this. That would be an indirect impact in that it is, having these agreements. We have no idea how many how many prosecutors are going to be willing to have programs with that would be available for this. Certainly, some of those folks, when you enter into the diversion agreement, you sign an affidavit basically listing the facts of the elements of the offense. And so, if you violate your diversion agreement, the prosecutor just walks into court and uses the affidavit as evidence. And so there could be instances there where individuals could indirectly be sentenced to prison. We just can't determine it at this time. So hopefully that answers that particular question. Again, we have estimates of 25, 50, or 75 as far as the Sentencing Commission's impact on the Senate Bill 123 program, which again, my office runs. It's a $9 to $10 million program that is usually a post-conviction program. Since we have the infrastructure in place, The idea would be we would continue to use the same treatment providers that are certified throughout the state and run it through our system, which we can do that. What I would caution the committee, we would suggest that the conservative amount is probably 75 new individuals for 2022. If you look at the impact itself, we already have, as of in 2018, when we did a survey of prosecutors that were actually diverting possession offenders, Wyandotte County actually had 85 already on their rolls that they were actually had in diversion. So more than likely 75 is probably going to be a more conservative number than 50. With that, we certainly would ask your support for this, just as the House has done, and I would stand for questions at the appropriate time, Madam Chair.
Thank you, Mr. Schultz. And committee will have questions for all the conferees once we've heard from all of them. I'll ask Greg Benefiel, Kansas County and District Attorneys Association. Looks like he's on WebEx, so please introduce yourself and welcome to committee.
Good morning. Thank you, Madam Chair, members of the committee, senators. My name is Greg Benefiel. I'm the McPherson County Attorney. I also appear before you this morning on behalf of the Kansas County and District Attorneys Association. I have submitted written testimony that is similar to my written testimony for SB3, so I will not necessarily touch on that, but I do want to make a couple of comments regarding HB 2026 and the general impact that we believe that it will have for particularly the county attorneys throughout the state that have far fewer resources available to them than the district attorneys. I have a case that that first arose a number of years ago. We have attempted to provide the opportunities for diversion for individuals charged with simple possession of controlled substances in McPherson County. And our anecdotal experience is that these individuals often, I don't believe we've had a successful one yet. We believe that HB 2026 will actually allow a greater likelihood, a greater opportunity for those individuals to actually succeed. We believe, as Mr. Schultz indicated, that a pre-trial, a pre-conviction program will speed the process along and get these individuals assistance earlier in their substance abuse. This individual that we had no prior criminal history. She ultimately was pled guilty to and convicted of possession of methamphetamine, and she was sentenced, and she's had multiple cases, multiple probation violations, and just recently was sentenced to serve her underlying sentence in KDOC. So Mr. Schultz indication that the bed impact is difficult to gauge, I think, is a fair assessment, because there is also the possibility that by offering this program, we actually will, hopefully, the goal is to have fewer individuals that fail and more individuals that succeed. We in the rural communities do not have the resources to have the staff to supervise these individuals in-house. I personally reached out to court services and community corrections. They were willing to supervise when I first became county attorney about 4 years ago, but they did not believe they had the statutory authority. OJA advised them that they did not, specifically to court services. So this specifically gives them the statutory authority to do that. Brandon Jones, the Franklin County Attorney and President of KCDA, relates that he also reached out to court services and got the same response. OJA says we can't do it. So we believe in communication with our own court services people. Mr. Schultz indicates court services is not opposed to this. It's simply giving them the authority to do it. And then we can work as a team on diversion, just as we do for convictions. We strongly support the passage of HB 2026. We believe it's good public policy. We believe it's consistent with judicial reform policy. I believe that there are more county and district attorneys throughout Kansas that would be willing to provide diversion and help those individuals avoid their first felony conviction if we have programs available like this. I'll be happy to stand for questions at the appropriate time.
Thank you, Mr. Benefiel. We will then hear from John Jenks, Greater Kansas City Chamber of Commerce. If you'll please introduce yourself and welcome to committee.
Thank you, Madam Chair and members of the committee for allowing me to testify virtually today. I am John Jenks, Director of Public Policy at the Greater Kansas City Chamber of Commerce. The KC Chamber urges this committee to favorably pass HB 2026 as we did with SB 3. So I won't go into too much detail either, as the other conferees said, as our testimony is essentially the same as the Senate bill. But as I often say, it's pretty unique for a chamber to care about these issues of drug treatment and criminal justice, but the KC Chamber looks at this through an economic and jobs lens. We view this bill as, and other similar legislation, as a bill of jobs opportunity, of growing job opportunities. As you all know, a person who is justice involved has a much better likelihood of success in rehabilitation if he or she is surrounded with family and support and is able to maintain stable employment through rehabilitation. This bill will keep folks participating in the workforce, which is going to be key as the economy continues to recover from the downturn we experienced last year and as baby boomers continue to leave the workforce for retirement. Expanding drug treatment programs for Kansans on diversion is a great step the legislature could take to show that it is serious in addressing the drug epidemic gripping Kansas and our country right now, and as most experts have said, has only gotten worse during the coronavirus pandemic. The Chamber applauds the efforts of the Criminal Justice Reform Commission and this committee and looks forward to working with you all down the road. The Chamber supports 2026 and asks this committee to pass this legislation with a favorable recommendation. I'm happy to stand for questions at the appropriate time. Thank you.
Thank you, Mr. Jenks. With that, I'll ask, are there any other proponent conferees in the committee meeting room or on WebEx? Seeing and hearing none, I will direct the committee and those listening online that we have proponent conferee written testimony from Mark Bennett, Kansas Criminal Justice Reform Commission, and Ed Klump, Kansas Association Chiefs of Police, Kansas Sheriff's Association, and Kansas Peace Officers Association. We have neutral conferee testimony then. We'll first hear from Randall Bowman, Kansas Department of Corrections. Thank you for appearing, Mr. Bowman. If you please introduce yourself and welcome to committee.
Thank you, Madam Chair, and thank you, members of the committee. Again, my name is Randy Bowman. I'm the Executive Director of Public Affairs for the Kansas Department of Corrections. And yeah, we just wanted to make sure that we were submitted our written testimony and available for questions. It is the same testimony we provided both on the House side for this bill and to this committee previously on Senate Bill 3. And basically, just to sum it up in a few words, we support this, as does everyone else, but we thought we should be neutral just to call into people's thinking the resource needs that might be needed. There's been some discussion today about, who will do this in district attorney's offices, who won't, and some difficulty in being able to measure it. So I couldn't quantify for you, but if community corrections were supervising some number of people, that might be a resource issue that'll need to be addressed down the road, as would presumably treatment resources. So with that, I'm happy to stand for questions for you and members of the committee. Thank you.
Thank you, Mr. Bowman. Next, we will hear from Stuart Little, Kansas Community Corrections Association. Please introduce yourself and welcome to committee.
Thank you, Madam. Thank you, Madam Chair. Stuart Little, Kansas Community Corrections Association. I appeared on Senate Bill 3. Just would simply remind you of the issue that I raised that's come up here in terms of who will be doing the supervision, court services or community corrections. Our interest is making sure that whoever the local jurisdictions, and it's not going to be a state matter, but locally, whoever decides is going to do that supervision, that the fees that are collected from those that are divertees, participants in the program, goes to the organization that is providing the supervision. The reason that is not in the House version of the bill that came over here is this issue arose after the bill had already come out of committee, 2026. And so that's why I brought it to Senate Bill 3 to this committee and come back and make those comments. I'd be happy to stand for questions at the appropriate time.
Thank you. Next, we'll hear from Kendall Seal, ACLU. Please introduce yourself and welcome back to committee.
Thank you, Madam Chair, members of the committee. Kendall Seal, Director of Advocacy for the ACLU of Kansas. We testified previously as neutral on this bill. Just to reiterate our main 3 points about this bill. The first, the diversion costs, we believe to be a barrier for some for successful program completion, weekly, monthly, or analysis fees, difference between paying rent and securing transportation. For some, these fees disproportionately impact people of color, which we believe reinforces structural racism within the criminal justice system. We strongly recommend eliminating the fines and fees associated with the diversion program. Second, we think the bill is too narrow in scope because it only includes level 5 drug offenses on the drug sentencing grid. People in possession of amounts that would be comparatively low in other jurisdictions in Kansas would be categorized differently and with severe implications. So the third point that we would lift up, and I think it's significant, especially as familiarity with the diversion programs and transparency and communication with the legislature is vital, that there's no prosecutorial oversight mechanism, nor an avenue for robust transparency in this bill. And at a minimum, we would recommend the inclusion of an annual report on diversion programs be shared with the committee. Including this provision will strengthen faith in the criminal justice system, and we support HB 2026 affirmatively with these adjustments.
Thank you, Mr. Seal. Are there any other neutral conferees in the committee meeting room or on WebEx? Seeing and hearing none. We don't have any opponent conferees signed up or providing written testimony in your committee folder, but I will ask, do we have any opponent conferees in the committee meeting room or on WebEx? Seeing and hearing none then, committee, I apologize we didn't pause after the proponent conferee testimony for questions, but we'll go ahead and open it up now for committee member questions to any of our conferees that have appeared today. Yes, Senator Corson.
Madam Chair, I just had a question for, I would just be curious what Mr. Schultz and Mr. Benefiel and Mr. Jenks would think about the ACLU proposed amendment, especially with respect to the part about eliminating fines and fees. I would just be curious if they had whether a position on it or just thoughts on that proposed amendment. Or not that, I mean, it's not formally a proposed amendment, but that idea that the ACLU testified about.
Do we have any conferees who would like to respond?
I would be happy to on behalf of KCDA.
Sure, please go ahead and introduce yourself again.
Certainly. Greg Benefiel, McPherson County Attorney, speaking on behalf of KCDA as well as myself. If there is a amendment that limits fees, fines, that type of thing, I think that we have to be slightly careful because there are additional costs associated to our offices in terms of time and such. So I think that some fees are appropriate. The policy that I've adopted in McPherson County is we look at it the same way essentially that the courts look at it for appointment of counsel. If a person is indigent, we will waive those fees. So our goal in McPherson County, and I think that there are many counties that take the same approach, not all, I will admit, is that we try to make certain that financial barriers are not a barrier to diversion, because diversion should not be something that one is able to simply purchase and get, those that have the resources are able to get diversion. So as far as eliminating fees, fines, I don't believe that would be necessary or appropriate, but some form of review of indigency by the county and district attorneys, a requirement for that, we'd be more neutral to. I think there are ways of addressing it without eliminating the fees and fines.
I'd be curious if Mr. Schultz has anything he would like to add from the.
Madam Chair, Scott Schultz with the Sentencing Commission. I would concur with Greg in terms of There is a balancing act that has to be done just simply because there are administrative costs that prosecutors have to do to run a diversion program, especially in smaller jurisdictions in which many of the county attorneys obviously are either a one-person shop or part-time shops, and so that's the consideration we're giving. We also, obviously in terms of agreements with the probation officers, they obviously there's language in the bill that provides for cost in that situation because they're incurring staffing costs as well. Like I said, it is a balancing act in terms of you don't want to have fees too high to be a barrier to access for diversion. And so, I think that there could be a common ground that could be found somewhere between where we're at right now and what he's proposing to get to. And I don't think that the commission and probably the Reform Commission has actually been pretty active in driver's license and other places about decreasing the fees as well. We don't think about this very much, but even in an offender registration issue where you have drug offenders that have to register, sex offenders that have to register, they have to pay $20 4 times a year. And even $20 sometimes is a tall hill to climb. So we kind of forget about that because we got 20 bucks in our pocket, but he does raise a good point.
Committee, any other questions? I want to bring to the committee's attention the issue of the payment for the diversion program and whether that's out of court services or community corrections. After the conclusion of the hearing on Senate Bill 3, I believe the folks from Kansas Community Corrections Association and I think it was the Kansas Sentencing Commission got together and like we asked them to and came up with a proposal that addressed some of the questions and concerns that were raised by committee members. So there is a balloon amendment proposal. It's pretty straightforward. We are not working the bill, but I would like to pass out the proposed amendment just so we can have the conferees who put this amendment together here for the committee so you can ask them directly any questions that the committee might have about it. So if we could pass out the proposed amendment. Again, we're not working the bill at this time. We're just hearing from the conferees about what their position is on this amendment, like we've been asking on some of the other bills when we hear proposed amendments. I think it's good to go directly to the source when we can. So with that, you will see, committee, on page on page 3 of the bill, there's some pretty specific language that actually talks about that the fees imposed by the bill would be charged and collected not by the district court, but by the county or district attorney. So with that, do we have a conferee who would like to first address the amendment? I'll call on Mr. Stuart Little, Kansas Community Corrections Association. Please introduce yourself and welcome again.
I appreciate the opportunity to address you again.
Make sure your microphone is on and you're speaking into it. Thank you.
Probably too far away. Here we go. I came to you with a suggestion about how potentially that to make an amendment. Mr. Thompson, your revisor, worked on one that altered the money around and attempted to make sure that the money went to follow the offender. What happened was the Office of Judicial Administration, so not Mr. Schultz, but the Office of Judicial Administration, who were the court service side of this equation, we got together and had a couple of conversations, went to Mr. Thompson, who drafted up this language, and I'll let him explain it from your technical side, but from my side, this places the decision of where the dollar should go in the hands of the county attorney and the district attorney and the local jurisdiction. So if they're, so in McPherson County, for example, and you just heard from the attorney there, or the county attorney, that they'll figure out who's going to supervise it, rather than going through the amendment that you all received the first time, which was a long change in terms of, okay, we're going to take money out of this account and this account and this account. You simply give them, not simply, there's still a process and procedure, and it's public funds, and it's going to be the county, but they will collect those funds, and then part of the memorandum of an agreement will be that if you're going to have community corrections supervised or court services, that's where it goes, and that's my non-attorney description of it. If Mr. Thompson has a clearer one, I'll stand aside.
Thank you, Mr. Little. Yes, if we could hear from the reviser, Mr. Thompson, on the proposed amendment. Thank you.
Thank you, Madam Chair. This is Jason Thompson with the reviser. For those watching on WebEx, I think I'm sharing the balloon, and I'm told it's coming through okay, so hopefully everyone can see that. The changes proposed here are to the sections that talk about the memorandum of understanding between the county or district attorney and the chief judge or community corrections. So we would add some structure here to say that when a person who has entered into a diversion agreement is supervised under one of these memoranda of understanding, they will pay the supervision fee, and that fee would be the same as what they would pay for under the other section that's cited there for misdemeanor or felony post-conviction supervision. So it's the same fee, just going to a different place. And then we would be clear that the diversion fee imposed shall be charged and collected by the county or district attorney. And then all monies collected by this section would be paid into the county general fund and used to fund the cost of diversion supervision performed pursuant to a memorandum of understanding. Finally, the diversion supervision fee could be reduced or waived by the county or district attorney in accordance with a memorandum of understanding that they have under this subsection. So the mechanics of it would be the fee is assessed, the fee is collected by the county or district attorney, all monies then go to the county general fund, and then they are used to fund the costs of the supervision performed under that MOU. And the magic of that language, we hope, is that if the diversion supervision is performed under the MOU with court services, then it goes to the courts. And if it was performed under an MOU with community corrections, it goes to community corrections. So it gets to the purpose that was discussed.
Thank you, Mr. Thompson. Committee, any questions for the reviser? Seeing none, then any questions for any of the conferees regarding the proposed amendment that we may be looking at when we work the bill? So I think then it must have been explained pretty well, because we don't have any further questions from the committee on the proposed funding for the bill if it were to be enacted. So with that, committee, then we will close the hearing on House Bill 2026, and I thank again our conferees for appearing in person and on WebEx, and for your thoughtful contribution and discussion. And with that, then we are adjourned. Thank you, committee, for your hard work today.